Long story short, boyfriend strangled girlfriend. She was pregnant. He strangled her for basically an entire day, basically 8 hours on and off of strangling her. It was a very horrific case. She was pregnant at the time. She ended up losing the pregnancy. He was charged with strangulation. The jury ended up finding him not guilty.
We are the Armed Attorneys. Today we are answering your questions. These are questions we receive in our comment section. If you want one of your questions asked, type out question, then what you have to say, and we'll get to it, hopefully, especially if it's interesting. And today we're going to be talking about a lot of fun things. Gunshot residue. How does that play out? What if you're a hobbyist? You got gunshot residue maybe on your person all the time, and you're in the wrong place at the wrong time. Talking about, what do we practically see with modifications in court? And then finally, a question we've been getting a lot, which is, can you check if your gun is stolen? You're buying these things in private sales, maybe. Is there a way to detect this kind of stuff? But before we begin, show your support for the Second Amendment by hitting that like button. Leslie Cross, good to see you.
Thank you. Thanks for having me again.
All right, we have some fun ones. We'll start this off with GCMjet 737 question. How can it be fair that a person be under investigation by a grand jury where the prosecutor gets to present all the evidence and the person being investigated doesn't get to present their side and may not even know they're under investigation?
That's a really good question. I think a lot of people would be shocked to find out that you can actually be investigated by a grand jury and never even know about it. A grand jury can serve as an investigatory body, and so basically they have subpoena power, so they can subpoena records, they can look into things. I could tell you at my time at the DA's office, I was very surprised by the number of HOAs that they investigated.
Oh, really?
Yeah.
I was in grand jury for a little while. I don't know that I had a single HOA case.
Yeah. And a lot of times nothing would come of it, but a lot of people would get upset with their HOA and kind of submit things, and they'd get investigated and then let go.
HOAs are illegal.
So, as far as getting actually looked at by a grand jury for an indictment, basically how that works is exactly how this question says. The prosecutor goes in and the prosecutor says, hey, grand jury, here's what the police report says. Find them, either true bill this or no bill this. If they true bill it, then it becomes a felony and it goes on and it's a case and the person is having to go to court. If they no bill it, then that's the end of it and it goes away. Now, you can actually get taken back to a grand jury for as long as the statute of limitations is. But typically, unless it's some sort of cold case or there's some sort of new evidence, they don't really take cases back to a grand jury. From our side, from the defense's side, we can actually ask the prosecutor and say, hey, before you take this to a grand jury, we would like to submit what's called a jury packet, a grand jury packet.
And that really only comes up you're a target of investigation because you've been arrested. You have a, let's say, forthcoming court date and haven't been, let's say, formally charged or under a charging instrument. So in those cases, you might get to participate a little bit.
Right. And really, those are only cases in which you have some sort of legal defense. So we're talking self-defense, defense of others, defense of third parties. If this is something where, let's say that it was a DWI third in Texas, and that's how you're getting to a grand jury. In that case, there really probably isn't any sort of legal defense.
Celsius. They accidentally mislabeled some alcoholic beverages.
I'd be interested to see how that played out in a grand jury. That would be good. But, we see this a lot in our self-defense cases. So a lot of times, we say that the facts are exactly the same as the prosecutor says, except for we say that our person is justified because they acted in self-defense, whereas the state is saying that it wasn't self-defense. And so we do what's called a grand jury packet. And so what we do is we put in our side of the story, our facts from our point of view, why we're justified. We put in the law and how the facts and the law line up for the justification and basically give the grand jury a reason to no bill our person. Now, interesting, we have no way to know if our grand jury packets ever make it in front of a grand jury.
Yeah.
There's no repercussion if the prosecutor takes them and just, kind of puts them
or
in the
rips
trash.
Pages out. This happened to Emily where the prosecutor was like, I'm just going to rip out the defense pages.
Yeah, we actually number our pages.
Now I prominently display the page numbers, and I think she even went so far as spiral bounding it, so it would be really obvious.
Yeah. So, it really is not a fair process. And Richard and I both were prosecutors. We both have presented cases to a grand jury. And, sometimes you go in there and there's not a whole lot. All you have is a police report, especially in, a case like a drug possession case or something. The person was stopped, they found drugs, they tested the drugs. Here's what the lab report says, and that's kind of all a grand jury hears. Now, obviously, bigger cases, a lot of times they'll have detectives come in, investigators come in, and it's actually a pretty big presentation to a grand jury, but it is very one-sided. You actually can make statements to a grand jury as the defendant. So you can go in and testify before the grand jury, but everything you say is recorded. There's a court reporter in there, and your defense attorney is not allowed.
Yeah.
So, we can't be in there to call balls and strikes. So I've seen it where someone's testifying and the grand jury just starts asking questions that have nothing to do with the actual case, but there's no one in there to stop it. And everything you're saying is recorded. So it's kind of a dangerous situation to be in as a defendant without having your attorney there to help you, which is why the grand jury packet sometimes is a better way. You get to put what you want before them, but you're also not subject to answering all of these questions under oath without having an attorney there to defend you.
Yeah, and it's one of those deals where, obviously I understand it from the government's perspective. They don't want to put folks, especially if they're in like a continuous scheme, like think organized crime or something like that. They don't want to put them on notice like, hey, we're investigating you. So I understand why that process is secretive. I get it. I understand. Unfortunately, the organized crime folks, self-defenders, they kind of get looped into the same rules, and it does feel inherently unfair. You even see that post-indictment. If there's some unindicted, co-defendants, sometimes they seal those indictments so people can't see,
Right.
Kind of what's going on. But yeah, it is an interesting process. That's something we've been working in the legislature, trying to resolve defense attorney access to grand jury. Obviously, these stories are very, very one-sided. We want to bring a little fairness to these things, especially if there's an affirmative defense. Why not get it resolved early in the process instead of dragging the person through the system?
Yeah.
So.
Next question we have is from Chris P. Bacon 512, and the question is there a way for a non-Leo to check to see if a particular gun is reported stolen? That could be helpful when buying a used gun from an individual or from a gun show.
Yeah, the short answer is no. There's no gun registry. I mean, there is a repository of lost and stolen property. All the states use it. When somebody reports that a gun is lost or stolen, theoretically, that information is getting placed into that database. And when law enforcement comes into contact with firearms, they can run serial numbers. Hey, does this thing show up in that database? For us, regular lowly people living here on Earth, no, there's no way to get law enforcement, this access to go query this database. And I've had folks do this. They're like, oh, I got a cop buddy. He ran a gun for me. Well, they're probably not supposed to do that. There's usually very strict rules on querying those databases. Has to be in connection to a criminal investigation. So, I'm not going to tell people to go, get folks in trouble querying a database when they're not supposed to. The only thing you can do is rely on your common sense. If you're buying it from a stranger, if the price is too good to be true, those things that kind of put you on notice that you knew or should have known that the firearm is stolen, trust your gut on that stuff. There is no private database to search these things, and so just kind of buyer beware.
Yeah.
All right, next one. This is from Mongo63A. He has a couple of questions, but we wanted to point out one that was I thought was really interesting. So he says, I'm an engineer, and every time I show up for jury duty, it seems I'm never picked as a juror, nor are my engineers I know. Do lawyers not like engineers on juries?
Yeah.
The short answer is yeah, kind of.
Yeah. I can tell you, we always typically see what someone does as a profession when we get the cards. And I know every state is different. And I know every county is different, actually, as far as what they ask the jurors on the jury questionnaire beforehand. But typically, we at least know what they do. If I see an engineer, I always strike them. No offense to engineers. Almost all of my in-laws are engineers. Love them. But engineers think very logically, and they want a lot of why for things. And sometimes, especially as the defense, we want jurors to rely on their, feelings and kind of common sense, because sometimes we don't have a lot of whys behind certain things. So yeah, I can tell you that I try hard to keep engineers off my jury.
Well, I just say, and it depends on there might be the right case for an engineer because, and I do this, prior to picking a jury. I think about who is my ideal juror.
Absolutely.
What's their level of education? What's their background? And I can imagine a case where, guess what? If I'm defending a driving while intoxicated case, I like engineers because they want to see the science. They want the government to meet their burden. They check all these boxes. Hey, you might be the right case for this. And the government knows the exact opposite. They know they don't want engineers on the jury. So I'll say self-defense cases are sometimes so much more technical with the legal requirements for justification. And these things haven't been updated in a very long time. And so arcane language plus, hey, there's a bunch of statutory requirements. It doesn't make for good cases, usually, in self-defense cases, engineers.
Yeah, I think it also might just kind of be a superstition thing.
Yeah, but I mean, there's cases where you don't want nurses. There's a case where you don't want teachers. Every profession gets a bad rap at some point. I have an engineer buddy who actually, he texted me a couple of weeks ago. He's like, hey, I'm at jury duty. What should I do? I was like, tell the truth. We need good people on juries, all these things. And he said, I need to get off this thing. I'm going to start talking about the Epstein files. And I was like, please don't do that. I didn't hear from him for a little while. And he goes, you're not going to believe this. I'm on the jury. He's like, what do I do now? I was like, just follow the judge's instructions. Don't talk about the case, all this other stuff. I come to find out later, he was the foreman of the jury.
Oh, no.
so he had a good time, but good experience. I mean, we need good people on juries, and engineers, y'all are good people. We need you on juries too.
And if it makes you feel any better, us lawyers get cut every time too. So we don't make juries either.
No.
The next one we have is from @JerryBrooks7883. And the question is, how much do you actually see pistol or gun mods in general coming up in court? I heard one lawyer say it rarely happens.
Yes, I agree with that lawyer. Whoever you heard that from, it rarely happens. And that's because, for the most part, police, the vast majority of police, prosecutors, doesn't come to their attention. I mean, they're, even when they go and have these like specialized training, folks who inspect firearms, those guys, for the most part, are just trying to determine, did the firearm malfunction at the time that it was used? Let's just use a self-defense case, for example, because they don't want the defendant showing up at trial saying, the gun went off by accident. I mean, they want to be able to rebut, for the most part, that kind of defense, or throwing out that defense or whatever. I'll say modifications, unless you're volunteering that information, they almost never know about it.
Yeah, they really don't. We see a lot on CSI and stuff like that where they really go in depth on looking at the firearm and looking at every aspect of it. And, they don't, in my experience. They really don't. A lot of times the prosecutor hasn't even looked at the firearm before they bring it to court that day to show it to a jury.
Yeah.
I've heard stories before where they've opened the box that the gun's supposed to be in front of the jury, and like the gun isn't even in there. Unless you have some, non-function enhancing engraving on the side, something that says like, I'm running out of bullets, you don't get a warning shot anymore, or, we use Smith & Wesson 791, something like that on the side of your gun, that's going to really come to their attention. Actually different triggers I've never seen come up or anything like that.
Yeah, or it's not uncommon. Replace a barrel, like,
sure.
They're not gonna, unless you bring it to their attention, it's not gonna come to them. Okay. All right, next one we have. This is from Doug Hudgens 9275. Question: any good stories from discussing a case with the jury post trial? I've been on 2 juries and enjoyed answering the lawyer's questions post verdict. Yeah, I guess it depends on your state. We do that in Texas. Mm-hmm. Jury deliberates, they come up with their verdict. Let's say they're released from all the instructions. Sometimes the court will say, hey, hang around. The attorneys want to talk to you. Sometimes they don't. But what's been your experience?
Yeah, I'd say probably half the time they'll stick around. A lot of times juries...
If it's 5 o'clock on a Friday.
If it's 5 o'clock on a Friday...
They're out of there.
They're out of there. But, a lot of times juries have a lot of questions because we talked about previously in another video, we talked about the rules of evidence and how not everything gets to come into a trial. And juries catch on to that. And so sometimes they want to know more. They want to know, well, what really, what was the behind the scenes? Or, they have other questions that they want answered. I have one story from being a prosecutor and then one from the defense side. But when I was a prosecutor, one time I had a case where it was a boyfriend and girlfriend. Long story short, boyfriend strangled girlfriend. She was pregnant. He strangled her for basically an entire day, basically 8 hours on and off of strangling her. It was a very horrific case. She was pregnant at the time. She ended up losing the pregnancy. He was charged with strangulation. The jury ended up finding him not guilty. And when I went back and talked to him, they basically said, well, we 100% think he did it. We didn't want to find him guilty, but we know that you'll catch him next time. This couple was actually from another state. The woman actually had to fly in to testify, flew back to the other state. Guy got off on bond, flew back home, and within a week was rearrested for assaulting her again. So that was a really interesting thing that a jury said to me that I thought, wow, okay. And
Yeah.
then on the defense side, I had one where the almost the same thing. The jury said, we definitely think your client was guilty. We really don't like what he did, but the state did not prove beyond a reasonable doubt that it was not self-defense.
I love that.
And so they followed the law. And so they couldn't find him guilty because they followed that jury charge. But they definitely didn't like what he did either.
Yeah, I had probably the most upset a jury was with me, and then they kind of relaxed after I talked to him. This was back when I was a prosecutor. This is a long time ago. It was a driving while intoxicated third. It was a felony. Didn't have a video. Didn't have any blood or breath tests. Had just the cop who pulled him over. Had really only one of the standardized field sobriety tests, which is called the horizontal gaze nystagmus, where you're looking at to see if your eyes are jumping. And so there was virtually no evidence in this case, but I knew the cop, knew he knew what he was doing. And we tried this case, and the jury was like, dude, you didn't have any evidence. Why'd you do this? And it was his 26th DWI, and he was on parole for DWI. So, I mean, he was 25 to life. It was one of those deals where he was already serving, I want to say, like 50 years. He had a previous intoxication manslaughter. I mean, there's a lot of reasons why, we get to see that stuff. Juries don't get to see that stuff. And I totally understand their frustration. But, the court did what it was supposed to do, kept the evidence, didn't want to bias the jury out.
Yep.
That wasn't supposed to bias them. And, I can't ever say when a jury comes to a conclusion that they get it wrong. For the most part, juries get it right.
I would say so. This one is from Connor Snook 776, and the question is, do jury's instructions also include precedent-like case law that is summarized?
Yeah, we can keep this one short. The short answer is yes. When a court issues and it's a binding, it's a binding on the trial court, if there's a binding decision on it, yes, those are reflected in the jury charges. In some states, what they do is their legislatures actually draft their jury charges. A lot of states, and this is how it is in Texas, we have kind of general guidelines that's produced privately by the bar here in Texas. That's reflective of the statutes. But as cases come and decisions come down, these things do get modified. And that's the biggest source of error. If a jury isn't properly instructed on the law, guess what? They're going to come up with the wrong conclusion every single time. And that's why higher courts always overturn these things. So the attorneys were all very cognizant of the current status of the law, wanting to make sure the jury instruction correctly reflects that. And that includes jury, case law.
Yeah, good question.
All right, this is a good one. This is ICKES. All right. It's been a little while since I cleaned my carry gun, so I've decided to take it apart and clean it. After I'm done, I go grocery shopping. Something happens along the way, either at the store or on the road. I haven't shot my gun, but I've contact with police and they find gunshot residue on my hands. Could that be an issue? Proving why. I get they can count the bullets in my gun. Still, maybe I'm overthinking this. All right, you got gunshot residue on your hands, but you haven't discharged your firearm. That could be an issue.
Yeah, it could be. Gunshot residue is kind of like fingerprints. It just shows that you recently were in contact with gunshot residue, potentially discharged a firearm. Same with fingerprints. It just shows that I recently touched something. Doesn't show when you touched it. Doesn't show when you came in contact with that gun residue. But especially with gunshot residue, it would show that it was probably recent, because typically after you wash your hands a few times, it kind of goes away. But yeah, that's a great point. They're not going to be able to say specifically when you had that gunshot residue on your hands, just that at some point you had gunshot residue on your hands, probably recently.
Yeah, and I'll say, we just had this happen in a town in our jurisdiction where they found out all their gunshot residue testing kits were giving false positives. And so, the stuff that you see on the scene, not very reliable. They have to send this stuff off to a lab. But even then, yeah, it's a data point, but, does it make it more likely that something happened or didn't make something happen? It's just going to depend on the facts of the case. We got one more question on the Franklin Armory antithesis, but I think we're going to save that for a whole video. There's an interesting court decision. I think we got to do a little bit of research on it, see what actually came out of that. But we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave your comments and questions in the section down below, especially type out question, so hopefully we can feature it in an upcoming video. And until next time, we're the Armed Attorneys.